Now, next up, we're going to talk about the power available to a very different type of government office, the International Trade Commission. This commission, though seldom used, can provide unique and expansive remedies for companies that are looking to protect their IP from infringing importers. Venturing into the ITC can be an intimidating process, but dramatic results can be achieved quickly and efficiently. Trial lawyer Jennifer Fitzgerald from Chicago's Freeborn and Peters office will provide some background and a list of questions to ask yourself before you file suit in this forum. Please welcome Jennifer Fitzgerald.
The power I'm going to be talking about is a little bit different, but it's probably something you haven't thought about. Because one day, one of your colleagues is going to come rushing into your office and say, we can't handle this infringement of our intellectual property anymore. And you're going to look at them and remember the last time you had an intellectual property case and how expensive it was and how the defendant just defaulted on a judgment that you got or closed up shop and moved down the street, started all over again. But this time you're going to look at your colleague and you're going to say, I'm happy I went to that network event because we should consider using the International Trade Commission. Now, of course, your colleague's going to look at you and say, I know nothing about the international whatever you just said. And you're going to say, well, the International Trade Commission, it's given power under 337, Section 337 of the 1930 Tariff Act. And he's really going to be impressed now. So he's going to say, well, I'm still not sure. I heard you can't get monetary damages out of the International Trade Commission. And you're going to say that's true. But remember, last time we got 0 as well. So then you're going to have to convince him that the International Trade Commission does actually provide some unique remedies that you can't get out of the district court. But first you have to prove you can be there. So the first question is, who's that defendant? Who is this person who's infringing our intellectual property? And your colleague's going to look at you and he's going to say, well, we don't know. Or it's some guy in some foreign country. Or it's a whole bunch of guys in foreign countries, and we're going to have to file all these different suits. And you're going to say, not a problem. You see, the International Trade Commission doesn't really care about jurisdiction over companies. Instead, it has in rem jurisdiction over products that are coming into the country. So if a product crosses the border, it is subject to the power of the International Trade Commission. And unlike in the district court with patent cases and the American Invent Act, which no longer really allows you to join multiple defendants, the International Trade Commission actually welcomes multiple respondent activities. So you have him beat there. Okay, so the other interesting thing about the International Trade Commission is companies that are importing into the United States are actually concerned about the impact of having an exclusion order that prevents the importation of their products. And so unlike in a district court case, it's actually more likely that a foreign defendant will participate in an International Trade Commission action because the International Trade Commission does not like being told, I'm not coming to your court. And they will issue exclusionary orders for a non-appearance. Now, in order to be a plaintiff or a complainant in the International Trade Commission, you have to prove that you have a domestic industry. Your colleague is going to say to you, but we're a U.S. company, of course we have domestic industry. Well, this is a statutory requirement, and it absolutely requires that you prove these elements. Now, there's 2 elements that you need to be concerned with. The first one is the technical prong, and this requires that you actually practice the intellectual property that you are going to be accusing somebody of infringing. So in terms of a patent, it would be that you practice your patent and you use that patented product within the United States. You can actually also license the patent to somebody who uses it in the United States, but you will need to prepare your claim charts that show that you are using this product or this patent or other intellectual property. The second piece you have to show is that you have to meet the economic prong. And that requires that you show you have a significant impact on the domestic economy. Now, you're going to say, oh, yeah, well, we're a U.S. company, that's no big deal. What you need to understand is that there's no bright line rule in order to satisfy this prong. And so a lot of complainants will actually use an expert to show their impact on the domestic economy. However, this is one of those areas that is really difficult for clients to understand, because where you're the complainant and you're showing a patent infringement, for example, you usually don't have to delve into your areas of manufacturing and research and development. However, in order to meet this prong, you absolutely have to provide documentation showing where you do your research and development, where you do your marketing, and failure to do so can be actually quite costly. So your client is going to have to bring forth that information. And I guess my word of warning on this is, if you haven't pulled out the blueprints of your factory and highlighted where the research and development happens and where the manufacturing happens of that product that is subject to the patent that you've already demonstrated, you have not likely met this requirement. So this is something that during discovery you're absolutely going to want to pay attention to. A lot of companies, a lot of situations, people will ask to stipulate to this point, and it happens quite frequently. However, what one of the respondents' sort of key tactics is, they'll say, well, we're going to investigate a little bit, and they'll delay and delay and delay until discovery closes. If you haven't gotten this information into the record, you are going to have a problem with this element, and you will be thrown out even on the eve of trial for failing to meet the domestic industry requirements. So now you've decided that you have a defendant that's possibly subject to the ITC, you can meet the domestic industry requirements. So the question is now, where do you file? And obviously you could file in a district court, or you could file in the International Trade Commission. The International Trade Commission will most likely be through trial in less than a year, and a final ruling on the case will be issued within 16 months. You will receive a schedule about 35 days after you file your petition, and once that 35 days runs, that schedule is going to be set. Moving or changing that schedule, highly unlikely. In all the cases I've had there, it's only happened once, and it's because the government shut down the day that trial was supposed to start, and we got 3 days. So once you've looked at sort of how fast are you ready to go to trial, what are your other things? Well, what are your potential remedies? What is the scope of your discovery? International Trade Commission actually has a very, very broad discovery. You can get discovery from third parties, you can get discovery from foreign entities, much easier than you can in the district court. And of course, it's the speed. You're going to be through trial in a year. Now that speed sounds great, right? But of course, speed comes with a cost. Overall cost for litigation in the International Trade Commission is very consistent with taking a patent case to trial. However, the time frame in which that happens is quite compressed. So where you may be spending several $1 million over a period of time, International Trade Commission, you're going to spend that much quicker. Additionally, cases in the International Trade Commission actually go to trial at a much higher percentage than they do in the district court. But there are the trade-offs of the speed in which you can get through it, as well as additional discovery. So let's talk about that discovery. Discovery powers are very, very broad, but don't be fooled into thinking that the federal rules of evidence apply. The discovery process in the Trade Commission are inspired, is the friendly way to say it, by the federal rules of evidence. Basically, the administrative law judges have incredibly broad powers. They will read the federal rules of evidence to give them unwielding power. Basically, what I can tell you is you have the ability to get the discovery you need, but you got to do it in the time that you've been given, which is maybe only 6 months. So if you need to go and get foreign discovery, you can absolutely do that. You want third-party discovery? Have at it. Judges, the ALJs will sign subpoenas and give you the discovery that you need. They also will file or will provide you with trial subpoenas. So if you need a trial subpoena for tomorrow or the day after, the judges will issue them. And be forewarned, if your third-party company receives a trial subpoena for an ITC investigation, don't even bother filing a motion to quash because it's not going to happen. Get on the plane, fly to DC, and tell the judge you're here because he asked you to come. Motions to quash, as I said, almost never granted. Motions to compel, almost always granted. They're very frequent. Get in front of the ALJ as quickly as possible. Gamesmanship and discovery, not a good idea. There are as many creative solutions to a discovery or gamesmanship as there are strategies that you could employ. It's just not a good idea. And then keep in mind that discovery deadlines are actually deadlines. You will get interrogatories. You have 10 days to respond. You don't respond, there's a sanction. You need to stay on it. When I go onto an ITC case, I kiss my family goodbye, and it's 9 months of working around the clock. That's what you need to expect. And really from the standpoint of a client, you are going to want to have somebody, point person, and available to your outside lawyers who are handling this case around the clock, because that's how quickly things come up. Now, of course, your colleague who was wondering about the ITC has now heard more, of course, than he's ever wanted to know, and he's a little bit despondent because this sounds really onerous, and it is, but there is one little shout out that the ITC gives you in some cases, and that's the Office of Unfair Import Investigations. Since an ITC case is effectively brought on behalf of the government, the OUII may assign a staff attorney to your case, and they are wonderful, wonderful people to have. They really provide a nice third-party sort of review of the case. They fully participate, they brief, they ask questions, they can ask for depositions. They have some limitations on where they can travel for depositions. Generally, they can't leave the country, except for if it's in a very rare situation. But beyond that, they're really great with giving you an unbiased view of your case. They can also give you some insight into discovery and how to try and wiggle out a couple extra days if you need something, but it certainly won't change the schedule. They're just creative in how they do their jobs. So, what are the remedies? Why would we want to go here? Well, there are no monetary damages, of course, but there are exclusion orders, and the exclusion orders take two forms, either a general or a limited exclusion order. Limited exclusion order only applies to the parties that are before the ITC. So whoever is the respondent, that's who it'll be against. However, it's not all that limited. In other words, if you bring a case and you're accusing windshield wipers or phones or printers, you may actually be able to exclude the importation by that person of every product, every printer that they make. The way an exclusion order gets written, you want to be very careful in accusing only those products you know practice your intellectual property. As a respondent, should you ever find yourself on that side of it, you actually want to put additional products into the case. I know that sounds crazy. Hey, accuse a few more of my products. But no, you really want to do that, because what you want to do, should you lose and get an exclusion order, you want there to be a bright line that says these infringe and these don't. ALJs, because they're administrative law judges, actually will provide opinions for you that allow you to continue to manufacture. If you don't include these additional products, your entire product line might be wiped out, and then you're going to have to request an advisory opinion in order to bring forth products into the United States. General exclusion orders, on the other hand, can apply to any product that's coming in of the type that is accused of infringing. So this, if you use windshield wipers or printers, this would be all printers that infringe the product, and regardless of who manufactures them. This is obviously not as frequently granted, but often used when you have a repeat complainant who is saying, oh, this company infringed, this company infringed, this company infringed, or where it's the same respondent who just keeps reestablishing themselves as an alternative respondent and importer. So again, it's actually a technique, and it's a good one if you're in an industry that is frequently getting infringed. So how do you enforce infringement? These exclusion orders, it's through the U.S. Customs and Border Protection. Expect that you will be going to the source or the location of the importation, likely the port. You'll need to educate the customs officers on how to do this, and you'll want to come up with a way that they can quickly look at what a product is and determine whether or not it infringes or not. And this is actually a really good place to work with your ALJ when they draft the exclusion order. We've been successful in getting things to be having to be color-coded in order to highlight a location where something can clearly show if it's infringing or not infringing, and the customs office loves that because it makes it much easier. In addition to exclusion orders, you can also get cease and desist orders, and this is a particularly important element when there's a lot of product that infringes already in the United States. So the ITC really governs the borders, but when there's product that's already in the United States, and actually respondents who are knowingly infringing, what they'll do as soon as they get an ITC action is they'll just start importing a ton of product. During your discovery, you want to ask multiple times, how much product do you have in the country? If you don't do that during your period of discovery, you won't be able to get a cease and desist order. You need to show the judge that there's a lot of product in, and that product that's in the country is actually diluting your ability to sell your product. The ALJs will issue various cease and desist orders. They're actually quite broad, and they can even include civil penalties if they're ignored. One of the eBay factors are not actually at issue in the ITC, primarily because there's obviously no monetary proofs that need to be shown. On the other hand, the public interest element does need to be shown. And this is that any order that comes out of the ITC must not dramatically impact the public interest. Now, this is one of the things that you want to show during your case, is that you can meet the needs of the public with your own product that practices the patent that was at issue. If your client's worried about collection of damages, you can file a district court case. It will be stayed in light of the ITC action. And then once you kill them in the ITC, your record that was prepared at the ITC will transfer over to the district court, and it will carry persuasive value. Confidentiality in the ITC, very, very, very seriously taken. Individual lawyers, not law firms, sign on. Any experts that are used actually need to be pre-cleared, so you provide the name of your expert to the other side. They have 10 days to decide if they want to object to that expert. But the weirdest thing to me about the ITC is, as much as we spend time with confidentiality, if you go on the private record, people are removed from the courtroom, they go into a room with white noise. I mean, they take it very seriously. But if you settle the case, the court actually requires you to publicly file your settlement agreement. And you are allowed to redact some information, but it's extremely limited, like how much money was paid, not the fact that money was paid. So that's something you want to keep in mind with respect to how you're going to deal with the settlement agreement. My final thoughts on the ITC is it's really a crazy place to practice law. It's wonderful. I would highly encourage you to consider it as an alternative to the district court if you have foreign defendants or foreign importers that are infringing your intellectual property. I would encourage you to continue to use your regular counsel. However, do not go into the ITC without somebody who has been to the ITC before. It is a crazy place, and if you're not ready, it will bite you. One of the best things about the ITC, though, is that as a complainant, before you file, get your ducks in order. Draft your discovery requests, prepare all of your documents for production, and as soon as that 35-day window runs, the protective order is put into place, serve it on the other side. They have 10 days. The timing is on your side. Take advantage of it.